saw Fred there. I thought he was here day late on the bail bonding. Oh, well. All right, let's reflect upon this, the 19th day of April, year 4, 2010, continuation of the April 2010 term session of the Lee County Circuit Court City of Hamlin. Now, we've gone for hearing in a combined fashion the cases of State of West Virginia versus Jennifer Bragg, State of West Virginia versus Jennifer Porter, and State of West Virginia versus Jonathan Means. As I understand it, these matters all arise from a set of common set of circumstances. They are all in a bound-over posture, and Mr. Green represents Ms. Bragg. Is that correct?
That is correct.
What's the bound-over number on Ms. Bragg, John? Do you have that?
Let's see.
If I've got that number there or not.
It's 10B13. That's what I have. And Mr. Kermeans is 10B11. And I believe Ms. Porter is 10B12.
Thank you, Your Honor.
You're welcome. All right. I'll note, as I said, that Ms. Bragg is here by her counsel, Mr. Green. Ms. Porter is here by her counsel, Mr. Navy. And Mr. Kermeans is here by his counsel, Mr. Wallace. These matters are all postured, I believe, having been forwarded from the Magistrate Court of Lincoln County and have come over following a determination by waiver or hearing of a finding of probable cause to be forwarded onto the grand jury for review. And as I understand, these motions come on for bond reduction in each and all of the named individuals. Is that correct, Mr. Green? Bond reduction.
Yes, our motion is to have bail or bond reduced, Your Honor.
Okay. Mr. Navy, is that correct?
Yes, sir.
And Mr. Wallace, is that correct?
Yes, sir.
All right. Mr. Green, your turn.
Your Honor, in this case, on 3 offenses that have been charged against Jennifer Bragg, the Magistrate Court, Ms. Tuttle, set bail or bond at $100,000 per each offense. The charges made in this case are malicious wounding, conspiracy, and attempted murder. What I'm here for Jennifer Bragg to ask you to do is to accumulate a figure or bond, one figure, in an amount that is sufficiently reasonable that she can make bond. Jennifer Bragg has lived in this county all her life. The primary purpose, of course, of bail and bond, as I understand it under the law, is the appearance of the defendant at the respective proceedings that are held in the matter. I've practiced law a few years, and I've never had a client who failed to show up in a criminal matter at a hearing that was set, and I would not anticipate that would be any problem with Jennifer Bragg in this matter. Now, in this case at the present time, we're asking reduction in bail. $300,000 is a figure Jennifer Bragg cannot make. I say to the court that that figure is given and is set is tantamount to denying to her bail of any kind. She cannot make that bail. I couldn't make that bail. She is presumed innocent in this case, and we're in a stage where I think the West Virginia law makes a distinction between pre-conviction request for bail and post-conviction request for bail. And I believe that the reason the court does that and the logic that falls into place with that is the fact that there has not been a conviction, and it is a situation where she has not been proven guilty. Bail under the law is not supposed to be for punishment. Bail, as defined in the West Virginia statutes, is for the purpose of appearance at the court hearings that are set throughout the proceedings. And it's defined as such in the statute as being for that purpose. Now, I'm aware that there is a statute that talks in terms of the considerations the court can make in determining bail. But they are that. They're considerations, and the prime thing that I understand the law to be that you're looking for is, will she show up at the hearings? Now, in looking to the statute that talks in terms of your considerations, which I believe it is, let me find the place.
It's 621C1 as outlined in State Ex Rel Gibbs v. Johnson. Those are the considerations.
Well, there's a case following that which sets forth State Ex Rel Huston v. Dustover. Let me get the site. Hutzler versus Dustover. It's a 1977 case, which is 6 years after the case you cite, and Justice Miller in that case points out that in 1965 they amended the statutes. It used to be, when Gibbs was in effect, that I don't know whether Gibbs was already decided, I guess, but anyhow, back in 65 you had to show good cause in order to get out, and so they liberalized the law on that, and the essence of it was that they adopted, at least the concurring opinion of Justice Miller in that case points out that the American Bar Association had in fact adopted a policy that they asked courts to follow, and it showed that, and said, I believe, that the law favors release of defendants pending determination of guilt or innocence. And the reason that's true is if you've got somebody in jail preceding trial, that's pretty harsh. They haven't been convicted. They're in there, they're taken away from their family, they're taken away from their job. It has a lot of implications, not only for them, but also for members of their family. Now, the United States Supreme Court, and I filed with the court a written motion, and the United States Supreme Court has said that bail is not to be used to capriciously hold somebody in prison. Now, if you go to the considerations, they do say that that you take into account the seriousness of the offense. Well, these offenses are all, even though there's three of them, are part and parcel of one incident or event. And if, in looking to this, of course, the criminal complaint that was filed herein, as the investigating officer says that the facts as he has alleged them in that criminal complaint are predicated